Very recently, the famous grocery delivery app Zepto approached the High Court of Delhi asking for a certain remedy. What they asked for is a cancellation of another registered trademark with the same name, Zepto. And in this petition, they basically asked for rectification or striking down of that other mark from the register. So the main ground they took in their rectification petition is that the person who had applied for that mark and registered it was not even commercially using it in the class that they had applied it for, right? So what this person was doing, as per Zepto, is commonly known as trademark squatting. So what is trademark squatting? Trademark squatting is when someone applies for a certain trademark without any intention of actually using that mark in business. Now, why would somebody in their right mind do such a thing? Why would they spend time, money, effort, to especially apply for a mark, have it registered without even using it in business? Well, this is where some people get very, very crafty. And I don't know if the defendant in this specific case really had such an intention or not, but nevertheless, the arguments that were applied were that the defendant was in fact carrying on trademark squatting. And what happens in such cases is that somebody applies for a certain trademark and then squats on it, or basically blocks the register for that particular trademark in that class of goods or services, right? So now, how do they benefit from this practice? This is the question that must be coming to your mind. So if somebody applies for a certain mark and gets it registered, and then there's another person or another entity which actually wants to apply for and register that mark to use it in business, for their commercial usage, then they'll have no option but to approach the squatter. This is because the squatter has already registered that mark, and if they don't approach the squatter, then when they file an application, the trademark registry itself will raise an objection saying that there's already a similar mark on record in that particular class of goods or services. Or even if they do clear the objection stage from the registry, then the party which already has that mark registered can file an opposition before the registry, right? So in such a situation, to avoid all this trouble, avoid all this hassle, the applicant who actually wants to use that mark for business would then approach the squatter, and the squatter would in turn extort basically a very large sum of money from this poor applicant in order to transfer that mark to them, or basically to have their own mark removed from the register and allow this other person, or give their consent to allow this other person to use that mark in business. Now, to overcome the prevalence of such malpractices, courts have actually passed a number of judgments, right? And in fact, one of the main grounds taken in rectification petitions or petitions for the cancellation of a registered trademark is similar to what Zepto filed against its defendant, which is basically the allegation that that defendant is squatting upon the trademark without any intention of actual usage. And courts have passed judgments that you should not engage in trademark squatting, and trademark squatting is a malpractice and it is a ground for removal of a mark from the register, right? Now, this is actually a ground that I have also taken against other parties in rectification petitions, where I have said that this other party is only squatting upon the trademark. And I have also done something similar in the case of domain name squatting, right? So domain name squatting is when somebody purchases a certain domain name, registers a certain domain name without any intention of actually hosting a website on it, for any purpose whatsoever. And the same thing happens here, that the person who actually wants to use that domain name for the website will then have to approach the squatter and purchase it from them. So in one case, a client approached us and they said that somebody had squatted upon their domain name, and they said, okay, can you please just help us go and purchase that domain name from that person? So I checked my client's records and all that. I saw that he had a trademark registration, not only in India, but in like 30 countries. So I said, why do you want to go and beg him for this trademark, for this domain name? Why don't we send him a legal notice in which we will explain everything. We'll explain how we already have prior rights in this trademark, how we have prior rights in this domain name. And this other person should actually be bound to transfer the domain name to us. And that's exactly what we did. And sure enough, we were able to, settle this matter at a very, very low cost for our client, and save him the hassle of, having to spend a huge sum of money to purchase the domain name that he actually was not legally obliged to purchase from this squatter. And this is something similar, if you have heard about this issue of domain name squatting. It's recently happened in the case of the Reliance Jio Hotstar domain name, where the squatter basically purchased the domain name of Jio Hotstar, anticipating a big merger between Reliance and Hotstar and Jio. And he intended to profit from it. He thought he'll use this money to go to Harvard. But what actually happened is that Reliance sent him a legal notice or warned legal action against him, that you may have to actually transfer this domain name to us because you are a squatter. So, ladies and gentlemen, squatting, whether it is domain name squatting or trademark squatting, is completely unlawful and is an unethical malpractice. Please do not do it if you're getting any such ideas. You may just end up facing a lawyer like me from the other side. And if you absolutely have to do it, at least hire a clever lawyer to strategize it well for you so that you can, make some gains from it if you really have to do this horrible malpractice. Although I would advise you not to do it. So I hope you enjoyed today's episode and found the content useful. Please feel free to subscribe to my channel for more such exciting episodes on IP and tech law. Thank you.